because unlike vitu kama commercial law, hiyo ni kitu Mr. Moya alikuwa shatufunza actually pale LLB. Hata kama hakuwa ameingia into details, alikuwa ametupea a lot of information yenye ukiwa nayo peke yake utakuwa somewhere better than mtu mwenye hajafunza na Moya. So basically sijui kama kuna haja nianze ku state what is criminal litigation, the how, the what, nini. So I just dive into the procedure. Sawa. So anytime you are answering any criminal litigation question, unafaa ukuwe na this format: the power, the condition, record na the remedy. The power is basically you are identifying the enabling provision. What makes you do this? What makes the prosecutor say this? What enables the police officer do this? Number two, the condition. That is, list the ingredients, the provisos that must be satisfied. For instance, the ID parade, they are the ingredients. They are the conditions that must be satisfied. List them. Are they met? While the police officer is exercising the power of ID parade, has he met all these conditions? Has he satisfied all the ingredients? Number three, the record. Here, confirm the court record. The OB affidavit reflects compliance. After the ID parade, and I'm using this just for example purposes, after the ID parade, did the police officer fill the requisite form? That is the P157. Did he or did she? Then lastly, the remedy. What you ask if breached. So basically, those 4 steps are very important in whenever you are answering any examination question. As I said, this is a method of how to stop you from understanding any criminal process. This method is how you stop understand any criminal process quickly. So for example, if a person was arrested without warrant, the power comes from the CPC. You have to cite the specific section, although not a must, and the police mandate, but the condition is reasonable grounds of suspicion and compliance with constitutional rights of an arrested person. The record is the OB extract. The charge sheet, chronology, and the court proceedings show when they were presented. Then the remedy might be constitutional relief, revision, bail, damages, depending on the context, or even being convicted. So, nataka tuki-approach any criminal question, we approach it in those 4 bases. Number 1, the power. Where are you getting the authority from? Number 2, the conditions of exercising this power, the provisos and everything. Number 3, does the record reflect everything that the power requires and the conditions must be met? Then number 4, what's the remedy? If you're appearing as for the prosecutor, what remedy do you want? What's the final output that you want? If you are for the defense, what are the remedies for your client? I think that's well understood. There is no need of tackling jurisdiction and structure of courts. That's so obvious. I think we can go to now arrests without warrants and with warrants, then plus drafting. So as we said, you start with the CPC definition of where do you get this power to arrest. Section 21 provides the arrest mechanisms. That is, the actual touching or confinement unless there is submission. Force is permitted when there is resistance or evasion. And the critical limiter is that nothing justifies greater force than was reasonable and necessary. I believe we are together up to that point. Maybe you can just thumbs up. Thank you. So we have said there are 2 types of arrest. That is the arrest with warrant and arrest without warrants. What does it mean practically? Without warrant does not mean without legal basis. The practical threshold is reasonable grounds or suspicion, and lawful police mandate. The defense attack is usually arbitrary arrest, fishing expedition, or intimidation. So this is one of the powers by police officer that must be exercised very, very cautiously, because mimi akinipata pale kama defense counsel, I'll first ask, what reasonable grounds or suspicion did you have before you arrested this person? Because basically we know that the criminal procedure is number one, investigation before arrest, not arrest then investigation. This is something that rarely happens in our judicial system in Kenya, but it should be number one, investigation, then arrest, not the other way around. If the other way around happens in any situation, then the police or the prosecution have the honors to prove what were the reasonable grounds or suspicion, and did the police have that such mandate. So as I have just indicated, the legal system accepts it, but does not concept arbitrariness. So your analysis should always turn on what information did the arresting officer have at the time that made arrest reasonable. If the officer cannot articulate that, then the arrest becomes vulnerable or arbitrary. So as a defense counsel, you ask for the OB extract and seek to show that no complaint or evidence existed, or that the arrest was for an ulterior purpose, that is harassment, coercion, or controlling information. Then for the prosecution, you must be ready with the arresting officer's factual basis. That is, there was a complaint, or the police officer knew the witness description, there's recovery of suspected property, or suspect found at the scene, identification, intelligence with corroboration, or contact pointing to the offense. Maybe if I can just ask us to jolt ourselves, what are the crimes arrestable by police without warrants? I think Tusha Somai, so we just reflect on section 29 of the CPC. Then number two, second form of arrest is arrest with warrant. There are reasons why warrants exist. So what is a warrant? A warrant is judicial authorization to arrest. It is used where the law requires it or where the court process needs coercion. Then number three, warrants protect both sides. They formalize authority and reduce dispute. So in practice, it is important in two categories. Number one, where the suspect is not easily traceable or has previously failed to attend court. Then number two, when the police want stronger legal cover and clear execution pathway, especially if entry or such complications may arise. For us, the key lesson is that warrant process is evidence of accountability. It puts the court between police power and liberty. Then for any of us who might become a defense counsels, warrants are also attackable if obtained through material non-disclosure or if executed unlawfully. But a valid warrant generally makes the why did you arrest me argument harder unless you show abuse. So I believe we can now see the difference between arresting with warrant and arresting without warrant. Arresting without warrant, the police ako matatani, he must prove what suspicion existed. But for authority with for arrest with warrant, the police officer is more protected. However, you can still attack it on the grounds of non-disclosure or the warrant of arrest was executed unlawfully. Tied to warrant of arrest is entry and search to effect arrest. The important points are that officer, that is a police officer, may demand entry if they reasonably believe suspect is inside. If denied entry, law allows forced entry in defined circumstances. Special protection where a woman is in seclusion occupies an apartment. Section 22 of the CPC authorizes entry and search for a person sought to be arrested. It requires that the person in charge allows ingress and reasonable facilities for search upon demand. If entry cannot be obtained, the law permits forced entry where a person is acting under a warrant and also in situation where a warrant could issue but cannot be obtained without giving an opportunity to escape. This section 22 has a very important proviso, protecting cultural privacy of women in actual occupancy who do not appear in public. Notice must be given and opportunity provided for withdrawing before entry. So, for any advocate acting for defense, this section is a rich source of cross-examination. You might ask, did the officer notify authority and purpose, demand admittance, and comply with woman occupancy protection where applicable? For prosecution, compliance supports legality and reduces later rights litigation. Think of it like a Muslim woman who is suspected to be in occupation of certain illegal or criminal conduct. Number one, you must give them opportunity to withdraw, or if they are not dressed properly, for them to dress in their hijabs and everything before the ingress. Reasonable force of ingress and outgress. That was entry to an apartment, a house, or something, searching occupancy. Then there is number two, searching the arrested person. Search on an arrest protects officer safety and preserves evidence. Must be documented what was recovered, from where, who witnessed, because poor documentation creates planting evidence allegations. These allegations are more on watu wa bangi. Mtu anashikwa na bangi kwa mfuko anaambiwa ni yake. So search is not just a routine. The legality and credibility of a search and recovery frequently decides cases involving drugs, stolen property, weapons, or counterfeit items. The most important section here is section 25 of the CPC. So, whenever your client is arrested, number one, you must insist on proper documentation. The inventories of anything recovered, who are the witnesses, then at least show the chain of custody. While searching an arrested woman, section 27 provides that whenever it is necessary to cause a woman to be searched, the search shall be made by another woman with strict regard to decency. Remember, I gave the example of a Muslim woman. But for searching a person, individual level, it must be done by a fellow woman. Kind of discriminative, Summer section 27, article 27, with masculinity. So, we have seen the issues of arrests, the searches, and everything. Now, we must go to the next step. What happens after arrest without warrant? The most important thing that you should ensure it's in the back of your mind is, number one, the 24-hour rule, and number two, the police bond logic. You either bring to court or release on bond. Bringing into court must be within 24 hours. Releasing on bond must be for trivial offenses. You can't release on bond for someone who has been arrested for accusations of, or for suspect of murder or the capital offenses. So the most important section here is section 36. It says, when a person is taken into custody without warrant for an offense other than murder, treason, robbery with violence, and attempted robbery with violence, the officer in charge of the station may release on bond. And importantly, if it is not practicable to bring the person before an appropriate subordinate court within 24 hours, the officer in charge shall inquire into the case, and unless the offense appears serious, release the person on bond with or without sureties for a reasonable amount to appear before the court at the time and place in the bond. You remember time ya maandamano last Monday, police, the OCS hapa Nairobi released watu kadhaa. on bond na hata wengine without bond. But it happens that alishikwa na to some extent akanyanyasa. I remember this LSK president akisema finally wamemtoa. But basically he was just exercising his power that he derives from section 36. The OCS may release a person arrested in suspicion when, after due inquiry, insufficient evidence is disclosed to proceed. So section 36 gives the OCS the power. Then there are the conditions or ingredients that he must meet. Did you do due inquiry? What kind of offense? Number 3, you must record that release in bail, in bond or bail. Basically, it's usually more bond, or more cash bail, yes. You have to indicate that this person has been released this day for this amount and must report in this station or in court at this time. You see now that's our format of power, condition, record, remedy. So whenever this aspect of releasing by the OCS is in contention, defense will use it to argue that continued custody was unnecessary where the offense was not in the excluded category and the case was not serious. For the prosecution, they'll employ it to justify bond conditions and to show that holding decisions were made within the structured discretion. Hapa the prosecution atakuwa anasema, no, there was, after due inquiry, there was no reason to release this person. Because number 1, there was no guarantee that atarudi station ama atakuja kotini. But for the defense, you will say that section 36 states clearly the offenses which cannot be released by the OCS: murder, treason, robbery with violence, or the attempted robbery with violence. So basically that is very important on any arrest made without warrant. As I said, the second important thing is surrendering the person in court within 24 hours. This is a duty under section 27. Police officers in charge of the police station, that is the OCS, must report to the nearest magistrate court of all persons arrested without warrants within station limits and whether admitted to bail or not. This is an underused provision, but it is very important for accountability and for challenging patterns of unlawful detention. I think that's very direct. The defense counsel can ask whether the report was made, and if not, use it to demonstrate lax compliance and support an argument of arbitrariness. Prosecution advising police should insist on compliance to avoid later constitutional exposure. I want us to have it in mind that whenever criminal litigation is involved, we are talking about beyond reasonable doubt. So as the defense counsel, look for anything to show arbitrariness or create some doubt for the freedom of your client. For the prosecution, you must always advise the institutions or the personnel that you are working close at, that is the police officers. Because if you don't, I think that's well understood, I believe. We go to the next important part, which is bail and bond. Section 123 of the CPC. As we have seen, bail can be granted by the OCS. And very obviously, it is usually granted at the court. An important proviso circumstances and must not be excessive. And the powers conferred to revisionary powers, the High Court can reduce or direct admission to bail. So, Section 123 covers 3 essential things. Number 1, when a person is arrested or detained without warrant, or appears before a court and is prepared to give bail, they may be admitted to bail. The wording is may, not compulsory. Number 2, the amount must be fixed with court as due regard to circumstances and must not be excessive. The wording is compulsory. And number 3, or reduction. Again, not compulsory. So, whenever your client is arrested and didn't have a bail or something in the court, and they are now in the OCS station, and they are now in court, and the court directs that you do an application for bail and bond, you file a notice of motion supported by an affidavit. Cite the powers, the conditions, the record, and most importantly, what remedy do you want? You also need to propose conditions like cash bail, bond, reporting, or no contact. Another important baseline that you must quote is Article 49(1)(h) of the Constitution. Right to be released on bond or bail on reasonable conditions pending charge or trial unless there are compelling reasons. You then meet it with Section 123 for the statutory mechanism. The wording of the Constitution is unless there are compelling reasons. So, having a bail or bond is as of right. There are some important case laws. I'll just read maybe one. In Echesa versus DCI and 2 others, the case arose from a constitutional application complaining of threatened or continued arrest and detention while investigations were ongoing. The issue was whether the arrest without warrant and continued restraint violated constitutional liberty and due process, and whether the court should intervene at an interlocutory stage. The High Court held that arrest without warrant is not automatically unconstitutional if there are reasonable grounds to suspect a cognizable offense and there is no absolute legal requirement that police must first issue summons before arrest. But the court's primary duty is to protect constitutional rights, and it granted protective or bail-oriented orders to manage investigation without unconstitutional detention. This directly implies that the legality of arrest turns on reasonableness of the suspicion, and that courts can craft orders that allow investigations while protecting liberty, meaning both sides should argue facts showing either reasonable suspicion for the prosecution or, number 2, arbitrariness, harassment, that is argument by the defense. This tracks down to our format. Did the police have the power? The conditions? Are they recorded? What remedy do you want? There is another important case here, called Titus Barasa Mahanu versus Police Constable Simon Kinuthia, Gitau, DPP, and AG. This case involved arrest in relatively minor context, where the petitioner complained of unwarranted and unnecessary force and failure to promptly inform him of rights. The issue was whether the manner of arrest and use of force breached constitutional protections against cruel, inhuman, and degrading treatment and the right of arrested persons. The High Court held that the force used was unjustified and violated constitutional protections and awarded damages, reinforcing that even where arrest power exists, the manner of execution must comply with the reasonableness limits. This mirrors Section 21(3), restraint on force. So, per this discussion, the defense should litigate excessive force and poor arrest procedure, while prosecution must train officers that brutality ruins cases and creates liability. This tracks down to rights of an arrested person. Number 1, they must be informed of the offense. The right to remain silent. the right to have an advocate or a closer person. They must be informed of their rights. They must be told that the information that they might give will be used against them in a court of law. So basically, whenever all these are violated, whenever Article 49 is violated, then you have a recourse in the High Court under revision. So fast forward, you go to ID parades. And up and I'll just be brief because I believe we all know what ID parades is and the purpose and the requirements. So number one is, where do we derive this authority? Although there is no a specific statute on ID parades, judiciously it has come out that there are two types of identification. Number one, the identification parade in the police station, and number two, the dog identification. ID parade is not a must, it's not compulsory, but it is encouraged. So as I said, Kenya does not have one single identification parade act. Instead, identification reliability is controlled through judicial principles in criminal appeals. Joey case is very authoritative in this. The Evidence Act, where identity is proved through scientific methods, that is, the evidence or the opinion of an expert. Where the prosecution relies on fingerprints, handwriting, or other impressions, you ground admissibility on Section 48 of Evidence Act, expert opinion, as I just indicated. There is a very important point that Madam Rosemel was pointing to us when the time that we were handling this particular topic. She said that identification parades for the defense counsel are the easiest thing that you can throw away. Why? Because you can attack outside things, outside the ID parade, things like the visual identification, the lighting. Was it in the evening? Was it in the morning? Was it inside a room? Could the other person see clearly? You see, those things. So when must police officer consider an ID parade? As I said, it's not a must, but when should the police officer consider such? Number one, where the suspect was not previously known to the witness, where the case will likely turn on a single identifying witness, where the suspect was arrested later away from the scene based on description, and where there is a risk the witness has already seen the suspect at the station, cell, or corridor. So as a prosecutor, you need to demand parade early when the witness did not know the suspect before the offense. Because if you demand it later, it will be challenged. For the defense lawyer, you want to know whether the witness gave a description to the police before seeing the suspect again. If there was no prior description, you push the after the fact reconstruction argument. You also look for prior exposure. If the complainant saw the accused at the police station, in a cell, or being paraded informally, then the parade is contaminated because it is no longer testing memory. It is testing whether the witness remembers the person they were shown. These are important aspects that you must note as a defense counsel. For prosecution, you have to be keen to guide the police officer so that if they call ID parade when all these things have not been met, all the conditions have not been met, then they are just wasting time. They are just wasting time. So, the anatomy of a proper ID parade, what the court expects you to prove happened. Number one, we talked about the authority, judicial precedence. Number two, the conditions. A neutral officer conducts it, not the IO. The witness is kept away from the suspect beforehand to avoid contamination because we are testing memory here. The suspect is placed among similar looking participants, not less than 8 for each suspect. And again, it's not 8. The wording should be not less than 8. The suspect can choose positions and can change positions between witnesses. Again, because the suspect is the one who has consented being subjected to this ID, he or she has the right to choose the positions, switch from this position, the other position, the other position in such a manner. And the police officer conducting this must be very cautious to ensure that the suspect does not retain one position throughout. That must be captured in the P156. If there are any objections, they must be recorded. The signatures should also be obtained. Then form P156 should be correctly filled. Important aspect, rights of an arrested person. They have the right to have their wakili or close family person. Very important aspects that should be evident in the P156 report. So what must appear in the P156? Number one, the administrative details, the date, the time, place, the officer conducting the same, the station, the reference to OB, the suspect's right and choices, the position selection, objections, representatives as I just indicated, witness management, the separation, no prompting, witness statement on prior familiarity, then the outcome. Was the suspect correctly identified or not identified? Was signed, and are there any remarks? So, as prosecution, you must treat P156 as an exhibit you will rely on at trial. The parade officer must be available to testify, and the form must match the testimony. From the Joey case, Lady Justice Nzioka was very mad on the process or the procedure how the ID parade was carried. It was into the pits completely. So you see the requirements that the ID has. For the defense, it's the easiest thing, kuangusha. For prosecution, it's the hardest thing to rely on. So, assuming you are in exam, our job will be to show that the parade reduced suggestion and increased reliability, or show that it increased suggestion and reduced reliability, depending on the side that you are arguing. That said, I wish to proceed to the next part, which is the doc identification, the least relied on. Why? Because think of this situation that you are the suspect in court. Already, uko hapo kizimbani. Then the complainant is asked, can you see the suspect or the person that you are complaining within this house? Definitely she or he will point on you. So it's almost worthless. Almost worthless completely if it is not proceeded by a parade. However, if the ID parade was carried on correctly, and now the dog parade now and the dog identification now comes to happen, and the complainant correctly points at the suspect who was identified at the ID parade, the corroboration there makes the evidence stronger. But still, not everything that you require. So, as I just indicated, the defense counsel must always ask, was there a parade? If not, why not? Did the witness provide a description to the police earlier? If not, the identification is usually weak. Prosecution must not wait for defense to raise it. As the prosecutor, you should anticipate the appellate scrutiny and ensure there is either a parade or a dependent evidence, recovery of stolen items, CCTV, fingerprints, call data, or credible recognition supported by prior acquaintance. So my point is, ID parade And the dog parades, although they are recommended, they basically are almost worthless. No court which will rely on the ID parade alone and convict the person. Rarely. So we have strategy for the identification cases. For the prosecution, don't treat identification as a witness issue. It is actually a case design built on the identification reliability matrix, that the lighting was okay, the distance was good, duration, obstruction, there was no stress or anything. Then, you need to ensure that prior description is captured in first report. Conduct parade early and preserve integrity. Then seek corroboration, because ID parade evidence alone won't suffice. And lastly, the P156 must be filled correctly. What about now the strategy of the defense? You need to attack the following things. Number one, the lighting. Was there opportunity to see? What was the quality of the lighting, the duration and stress conditions? If there was absence of prior description or inconsistencies in description, then kill that parade report. Any prior exposure, the witness came to the police station, they saw the suspects, they were caught, say that is contamination. Then demand corroboration. CCTV, any other information that must be filled. Who conducted this report, this ID parade? If it's the IO, tupilie ID parade mbali kabisa. Then lastly, very important, did the accused person consent to the parade? Some important case laws on parade. James Otieno Nyagilo versus Republic, 1996 case. It concerned a robbery conviction resting mainly on the complainant's identification of the appellant. The core issue was whether the identification was safe, where the witness did not arrest the accused. The arrest circumstances were not directly supported by the identifying witness, and the in-court ID, that is the dog identification, was effectively without a prior parade. So the Court of Appeal held that identification evidence must be treated with caution where it is the only evidence, and that dog identification without prior parade is almost worthless. And any conviction based on this will most times be quashed. So, if the prosecution fails to conduct a parade where the witness did not previously know the witness, the case is likely to collapse on appeal. Per the cause outline, the next part is preparation of files for trial, the police, prosecution file, defense file, the court file. And I don't think I'm in a position to handle that, because the same had been discussed earlier by Victor Cheruiyot. We now go to complaint and charge. How criminal proceedings are instituted. There is the complaint versus arrest without warrant. Whenever there is a complaint, a warrant will be issued so that it can give the arresting officer the power to arrest. But whenever there is no complaint at hand and the police officer arrests based on suspicion, then that will be an arrest without warrant. So a case can begin by complaint or by bringing an arrested person to a magistrate. Magistrate can refuse to admit a complaint or charge that discloses no offense. And lastly, this is a legal filter to stop abuse and incompetent charging. CPC makes it very clear that criminal process starts in specific ways, not by informal arrangements. Section 89 is very fundamental. It says, proceedings may be instituted either by making a complaint or by bringing before a magistrate a person arrested without a warrant. A person with reasonable and probable cause may complain to a magistrate. The complaint may be oral or written. So if oral, it must be reduced to writing and signed. When the magistrate receives the complaint or an accused person is brought before her or him, the magistrate draws up or causes to be drawn up, signs a formal charge unless police officer signs and presents it. So the key safeguard for defense and for judicial integrity is Section 89.5. It states, if the complaint or formal charge does not disclose an offense, the magistrate must refuse to admit it and record reasons. So practically, this is an early quality control stage that prevents people from being dragged into court on non-offenses. Our lecturers have insisted a lot that the golden rule of charge drafting is that it must disclose an offense and have the ingredients. As I said, authority, ingredients, recording, lastly the remedy. The charge sheet draws authority from what? Which is the contravened section of the penal code or the contravened section of any such statute. Number 2, the ingredients. Define the particulars. Number 3, it must be recorded in the charge sheet. And you realize that an unsigned charge sheet is not a charge sheet. Even in exams, you must sign your charge sheet. And lastly, the remedy. Prosecutor anataka aje this person to be convicted. There are important aspects in a drafting of charges, the joinder of counts, alternative charges. Number 1, on joinder. This is when you can put multiple offenses in one charge sheet. Joinder is allowed where offenses are founded on the same facts or similar series. Each offense must be in a separate count. And courts can order separate trials if joinder embarrasses the defense or is unfair. Some people believe that whenever you find a charge which is duplex, a charge sheet which is duplex, you can just do it during the hearing and kill it. No, that's not the right way. Because even at that time, the court might order the charge sheet to be rectified. So joinder is governed by Section 135 of the CPC. It permits offenses, whether felonies or misdemeanors, to be charged together in the same charge or information if they are founded on the same facts or form part of the series of offenses of the same similar character. Same transaction is the right word. This section requires each offense to be in a separate paragraph called a count. Just a minute, guys. Sorry for that. I think you can continue. So Section 135(2) requires each offense to be in a separate paragraph called a count. And I said the safeguard is fairness, to ensure that the defense or the accused person is not embarrassed by the whole process. Section 135, subsection 3, if the court thinks the accused may be embarrassed in defense by being charged with more than one offense in the same charge, or for any other reason it is desirable, the court may order separate trial of counts. Prosecution uses Section 135 to promote efficiency, where offenses arise from one transaction, eventually saving the court's time. Defense uses Section 135(3) to argue prejudice, that the accused will be forced to defend multiple unrelated allegations together, increasing the risk of bad character reasoning, where the court assumes guilty by accumulation. I think this should be a bit higher on the time of on the part of arrests, because apart from the police officer, a private person can arrest, and so can a magistrate. For a private person, they arrest without warrant, and it is in very limited circumstances. They must deliver the suspect to the police station promptly. Then the police must decide whether the case falls under arrestable categories or release. The powers of the OCS. Remember the ingredients. Sorry for that. So, still on the charge sheet and the drafting of a charge sheet, there are issues which might arise. Number one, the defects, joinder, any amendment or motion to quash or dismiss. So a charge in itself should be considered as litigation per se, not the typing or whatever you're just including. Number one, a charge is the legal frame of the trial. It controls evidence, submissions, and sentencing. The moment you draft the charge sheet, you must confine yourself as a prosecutor to whatever is in the charge sheet. You cannot introduce a new allegation which is not captured in the charge sheet. Submissions must revolve around there. The evidence that you present or adduce in court must be aimed at proving whatever is in the charge sheet. If the charge sheet is defective, the entire trial can become a nullity or be reversed on appeal. But as I had indicated earlier, the court may, on their discretion, order the charge sheet to be rectified. So a charge sheet is basically the map of what must be proved, the Ramani. In a criminal case, evidence is laid to prove the elements of the specific offense charged. If you draft the wrong offense, omit an ingredient, mix offenses in one count, or misdescribe the property, person, place in a way that misleads the accused, you risk violating the accused's rights to be informed of the charge with sufficient detail under Article 50. And that risk might be incurable depending on the JO that you meet. So the defense's first job is to interrogate the charge before the plea. Even if every word is true, does this disclose the offense cited? For prosecution, they must ensure that the charge complies with CPC and matches the evidence actually available. So, for the defense, always think of it in this way. Have I challenged the arrest? Yes. Kama sijafaulu, number 2. Now tuko kotini. It is my time to challenge the charge sheet. If I don't kill it this time, then the chances of winning the case zinaenda zikipungua. So, the following are the ingredients that each charge sheet must contain. It must state the specific offense, particularize, and the accused person must be able to understand what to answer and prepare a defense. Remember, that is as of right under Article 50. The accused must be informed of the charge with reasonable detail. That is, again, anchored in Section 134. So the language is intentionally broad because it applies to all offenses. The charge is sufficient if it contains statement of the specific offense, and such particulars as may be necessary to give reasonable information as to the nature of the offense charged. So, particulars must cover the legal ingredients and must identify the transaction with enough precision. Date, time, range, location, nini. We are citing defilement contrary to what section of the Sexual Offences Act. You must state the exact section. The particulars, remember the ingredients. Penetration, the age of the child must be proved. What must be proved? Must be adequately captured. So that the accused person will know that, number one, I'm going to defend that there was no penetration or attempted penetration. Number two, I'm going to prove that I didn't know. After caution and after doing all the reasonable steps, the child was not below the age of 18. You see, you are not putting the accused person in a situation where they can't defend themselves. They know exactly what am I going to defend. There is the rule against duplicity. One count must charge one offense. Charging two distinct offenses in one count is duplicity. One count, two distinct offenses. Talking about rape and attempted rape in one count. That is duplex. So duplicity usually cannot be cured as a mere technicality if it causes prejudice or uncertainty. Remember, embarrassment of the defense. So Section 135 requires separate counts for separate offenses. The policy, as indicated earlier, is fairness and to prevent embarrassment of the defense. In Samuel Mutinda Kasioka vs. Republic, this case concerned a conviction where the charge combined receiving and retaining stolen property in one count. The issue was whether the count was fatally defective for duplicity and whether a conviction could stand where the accused could not tell which distinct offense he faced. The High Court held that the charge was duplex and violated the rule requiring one offense per count, and found that the defect is substantial and prejudicial and quashed the conviction. Thus, duplicity is not harmless drafting. It is the charge. If the charge merges distinct offenses, the trial outcome is very unsafe. By the way, Samuel Mutinda Kasioka is my previous boss. Joinder of counts. This is legal way of having many counts, of having a different accusation in one charge sheet, but being very cautious not to suffer duplicity. So offenses may be joined if founded on the same fact or part or similar series. The correct wording is same or similar transaction. However, each offense must still be in its own count. Section 135 once again, to prevent embarrassment and promote fairness. So, joinder of accused persons, we have now moved from the joinder of charges, that is a joinder of counts, and we are now on joinder of accused person. In a similar way, where in civil case you can have the first defendant, second defendant, third defendant, because they form the similar transaction or the transaction involves them all. In criminal cases, we call that joinder of accused person. These are people who can be charged together if the allegation offense is in the same transaction. Joinder must not complicate fair trial rights, and defense can push for severance when prejudice is real. Remember, a minor can or may be joined in adult offenses if they are in the similar transaction of the offense alleged. This is controlled by Section 136. Prosecutors join accused to present the full transaction and avoid inconsistent finding, but defense counsels must test whether the accused really participated in the same transaction or is being joined for convenience. If an accused person has an antagonistic defense, it was him, not me, Wakili may argue embarrassment and seek separation. The principle remains: efficiency is not allowed to destroy fairness. So in charge sheet, the most important point is fairness. Is their charge disclosed? Is it particularized? Weshika tu hizo. Whenever a charge is defective or the prosecution says that there is an issue with it, they can always apply for amendment. So the court may amend when there is variance between charge and evidence. After amendment, the accused person must plead afresh with the altered charge. Then the accused has a right to recall witness for fresh evidence or further cross-examination. If misled by time variance, court can adjourn reasonably. So the controlling provision is section 214. This must be understood as a sequence. Number one, the charge is altered. What next? Court calls upon the accused person to plead to the altered charge. Number three, the accused may demand recall of witness further cross-examination. If time variance misled the accused, court adjourn for reasonable time. So basically, whenever you amend the charge, assuming the hearing had already taken place, you're just restarting the whole process. A case law here, Jason Akumu Yongo versus Republic, 1983 case. It arose from a trial where the charge was amended to reflect evidence, but the court did not properly comply with the statutory safeguards on recalling witnesses. The issue was whether the failure to record or offer the accused the Section 214 right to recall witnesses after the amendment prejudiced the defense and vitiated the conviction. The Court of Appeal held that non-compliance with Section 214 is material omission, and it quashed the conviction. So, our format again, the power is under Section 214, but they are the ingredients, the conditions that must be met, the same as it been recorded in the proceedings. If not, what's the remedy? Quashing. In High Court, the charge sheet is called the information. So High Court trials on information have their own discipline under Section 275. Subsection 1 is important. Objection to formal defects must be taken immediately after the information is read. Subsection 2 empowers the court to amend defective information unless amendment cannot be made without injustice. Once again, the format: authority, condition, record, remedy. Here's an example of an application to save accounts. You use it when multiple counts cause embarrassment. That is, you are now the defense counsel. Authority is Section 135. What kind of relief are you seeking? Either separate trial for specified counts, or separate charge sheets, or even quashing the whole thing. You do it in a form of a notice of motion under Section 135, blah blah. Take notice, this. So the orders that you are seeking is the court be pleased to order a separate trial of counts, that is, the counts that are joined together, in the charge sheet dated so and so. Then the costs be in the cause. You need to give the grounds that the charge sheet contains multiple counts not founded on the same fact or transaction, forming a series of offenses of the same or similar character within the meaning of Section 135. That the joinder of the said counts will embarrass the accused in his defense and occasion prejudice, contrary to the spirit of Section 134 and Article 50 of the Constitution. That the counts relate to separate transactions occurring on different dates, involving different complainants and different evidential narratives, thereby risking confusion and guilt by accumulation. In short, we are just proving the spirit of Section 134, 135 of the CPC. then you need to attach the supporting affidavit, which identifies the count, shows the facts and distinct, explains specific prejudice, how you are affected, then what remedy are you praying for. Plea and plea bargains. We are moving on the assumption that the arrest was lawful. Bail or bond was issued or denied lawfully. The charge sheet was lawful. Now the next important step, plea and plea bargain. So the accused person is brought to court, and section 207 is the controlling section there. Okay, my screen is not moving. Tunaweza ni stop alafu ni nini? Screen yangu haitembei. Imeanza kutembea. So the controlling provision is section 207. So the substance of the charge is stated and the accused is asked whether he pleads not guilty, guilty, or guilty subject to plea agreement. The authority is section 207. Then the proviso or the conditions or ingredients is on section 207. The proviso allows the complainant to outline the facts after conviction, but before sentence. In practice, prosecution still state facts, so the record shows factual basis. Not something better. The reason plea taken is strict is because guilty plea waives a full trial. That's why in capital offenses that attract capital sentences or punishment, the accused person must be brought in again, told the ramification of accepting the charge or pleading guilty, and given another opportunity to plead guilty or not. Because in the moment he pleads guilty, confirms the guilty plea, he has now waived the full trial. And the next important step is sentencing. Of course, after mitigation. So, courts therefore require the record to demonstrate understanding, voluntariness, and factual admission. If the record does not show this, then the plea is equivocal and is set aside on appeal or revision. In the case of Otieno versus Republic, 2023 case, the case involved a conviction on a guilty plea where the record did not show the facts were read out and admitted and did not indicate the language used. The issue was whether the plea was unequivocal under section 207 and the established plea taking safeguards. The High Court held the plea was fatally defective and equivocal, quashed the conviction and set aside the sentence and ordered a fresh plea before different court. This shows what? The power, section 207. The proviso, or the conditions and ingredients. The record, does it show this? Then what are the remedies if it shows or if it doesn't? The equivocal plea, red flags, you must spot immediately. As I have demonstrated earlier, the plea must be unequivocal. So, as the defense attorney or wakili, how do I attack or identify these red flags? Number one, if the language of the proceeding is not recorded or accused understanding is unclear, the facts are not stated by prosecution or not admitted by the accused, the accused mitigation introduces defense, alibi, ownership explanation, lack of intent, and the facts do not cover every ingredient of the offense charged. So when the accused person says it's true to a charge, that's not the end. The court must still confirm the facts and ensure the facts match the offense charged. If mitigation contradicts guilt, the magistrate must not sentence on that plea. The court should not the court should enter not guilty and proceed to trial because the accused is effectively disputing an ingredient. Therefore, the plea must be unequivocal. In Evelyn Kemunto versus Republic, the case arose where the accused pleaded guilty, but the trial court failed to give her an opportunity to respond to the facts outlined by the prosecutor. The issue was whether omission for the facts stated and admitted stage made the plea defective under Section 207. The High Court held that the process was incomplete and therefore unsafe, quashed the conviction, and set aside the sentence. In real scenario, the court must ask this question: umeshtakiwa na hatia ya kunajisi mtoto mdogo, kweli si kweli? Nasema kweli. Inasemekana tarehe bla bla mahali fulani fulani ulishikwa na huyu mtoto ukimfanyia hivi na hivi na hivi, ni ukweli ama uongo? Ni ukweli. That shows what the charge has been read. Then an opportunity for admitting to the facts of that case has been given or read to the person. Therefore, if the person still pleads not guilty, then that one is unequivocal. Lakini akisema nakubali, lakini nilikuwa mlevi, that is not guilty. That is not plea of guilty. It is not unequivocal. He has pleaded a defense. Therefore, a plea of not guilty should be recorded in the court's file. So the accused person can plead either guilty, not guilty, or number three, say I'm guilty, but I need a plea bargain. So the CPC section 137A gives an opportunity for negotiation. However, we should note that this opportunity is given after a charge has been read, and number two, before judgment. That's the window. It must be negotiated by an authorized prosecutor, and the court must not at all participate in the negotiation. The court must record advisories, that is the rights being waived, the penalties, forfeiture, compensation, appeal limits. However, and a very important thing, even if the prosecution and the defense conduct a very good negotiation, the court must be satisfied that there is a factual basis. This is to say, the court can still refuse the plea bargain. So, Section 137 expressly contemplates charge reduction to a lesser included offense and withdrawal or stay of other charges, and allows restitution or compensation terms. It must be after the accused has been charged and any time before judgment. The court must address the accused on the rights listed, notify the accused clearly that the following are the rights that you are going to waive. These are the implications, and it must confirm whether the accused understands the trial and presumption of innocence. The accused understands the penalties, including maximum and any mandatory minimum, must explain the forfeiture and compensation powers, and must explain the limited appeal consequences. Section 137F 2. Prosecutor lays the factual basis, and the court must be satisfied a factual basis exists. Tuko mada, alafu nataka plea bargain. What for? The court must be actually satisfied. This is an example of a plea agreement. It's drafts, therefore lazima uiweke nyama. You just state the parties, the charges, the agreed factual basis on blah blah within this, the accused, you read the facts clearly, you link the ingredients. The accused admits the above facts are true. Upon conviction on the agreed plea, the prosecution shall withdraw or state the following. The accused agrees to pay this amount. Then sentencing. The prosecution will recommend this. The defense will urge this. Parties acknowledge sentencing remains the court's discretion subject to law. You will negotiate vile unataka, but the court has the final say. Then, just like any other contract, it must be voluntary. There need to be a clause that the accused confirms the agreement was entered voluntarily, without threat or inducement outside this agreement. The court has explained or will explain before acceptance the rights in section 137F, and the accused understands the waiver of full trial and the limited appeal consequences. Dated, blah blah, signed by the prosecutor, the accused person, or the advocate of the accused person, if present. As I indicated earlier there, this is an example of a model charge sheet. I just listed it for the sake of ingredients that we must show, not the format that's actually in the real charge sheet. So after setting the names, blah blah blah, nini, you have to state statement of offense. Stealing by servant contrary to section 281 of the penal code. Particulars. AB, male. On the 5th day, you give the particulars, Westlands, nini, aliiba this and this and this. Count 2. Remember, joined of offenses. Statement of offense. Handling stolen goods contrary to blah blah blah. Because why? Because they form the same transaction. This is the alternative to count 1, if you wish so. Count 3. Personation contrary to section 382 of the penal code. I gave the particulars. However, you'll note that I indicated this count 3 deliberately so that we can understand the issue of joinder tests. Does count number 3 fall in the same transaction? So this is how you read this model for the sake of learning purposes. You must show the forum and file number. This matters for jurisdiction, blah blah. Statement of offense and the particulars of offenses. Very important. Actually mandatory. Why is count 2 an alternative and how to draft it safely? Why is my screen hanging? Hello? Why count 2 is alternative and how to draft it safely. Alternative counts are used when the prosecution evidence may support one of the two theories, but you cannot properly pursue both as primary convictions for the same. Double chance, in short. Unakia goal ama draw. So the particulars in the alternative must explicitly show it is otherwise than in the cause of stealing. So it must be conceptually separated from the first count. The test is this. Even if the first count is not there, can this count stand alone? If yes, it is properly a joinder or an alternative charge in the meaning of jointer of counts. Why count 3 is allowed on the same charge sheet? Under section 135, counts may be joined if founded on the same facts or form part of the series of offenses of same or similar character. In real practice, you must justify joinder. If count 3 is totally different from transaction, defense will apply under section 135 for separate. If you are the prosecutor and you cannot articulate the connection, do not join. Just file separately. I think that's well understood. I can read just one case law. Josephat Shikoku versus Republic. This case involved a conviction founded on a charge sheet that improperly combined offenses in a way that created duplicity. The issue was whether conviction can stand where the charge fails to comply with the CPC rule that each offense must be a separate count and the accused is not clearly informed what offense he is being convicted. The High Court held the defect was substantial and prejudicial, not curable as a mere technicality. Conviction quashed and set aside the sentencing. The lesson is that if your charge is duplex or you place alternative offenses in one count instead of separate counts, you risk collapse of the entire case on appeal. Very important. The issue or principle of fairness or embarrassment of the defense. You remember the case of Samuel Kasioka, my boss, in the Moesha Pojo. So for charge sheet, I have this checklist that you should identify. Number one, identify the offense creating section. Power. Unatoa wapi power? Draft the statement of offense and the particulars. Condition or ingredients. If charging multiple offenses, ensure you do the joinder test. If it is alternative, label it clearly and draft it as a complete offense. Ask this question. Would this joinder embarrass defense? If yes, for the prosecution, do a separate one. If yes, for the defense, faster, fanya application here, severance under Article 134, under Section 135(3). I think that's a well captured. Tulikuwa tushaongelea story na bail and bond in court, in police station. The most important thing you should know is that it must not be excessive at all, and it must reflect the current circumstances. It is discretionary in the court and controlled in the police station. There is also the aspect of sureties. So if sureties accepted are insufficient through mistake, fraud, or otherwise, court can order fresh sureties. That is, you are given a cash bill of 50,000 or bond of 500,000 with 2 sureties. But in providing these sureties, you do so in fraud or otherwise mistake. The court has the power to order fresh sureties. And the chances of getting that bill have diminished because the court will issue warrants, kwanza ikurudishe kotini, warrants of arrest. And if in any way you don't find correct sureties, the court will issue your committal. Tutakesi kwa rumande. I think that's well captured. Then there is the discharge. The surety in his or her capacity may apply at any time to discharge the bond wholly or as to that surety. Magistrate must issue warrants of arrest to bring the accused before court. Then the court discharges surety and orders accused to find fresh sureties or be committed. Yes, your surety anasema amechoka kusimamia, anataka kuwe discharged. Then you must be brought back to court after issues of the issuance of warrants of arrest. Then, if you don't give another surety, committal to remand. This is commonly examined and commonly litigated. The basis is Section 128, not the mandatory language. Once the surety applies, the magistrate shall, compulsory, mandatory, issue a warrant of arrest directing the accused to be brought before him. If the accused appears by warrant or surrender, the bond is discharged for that surety, and the accused is called upon to find another sufficient surety, and failure will lead to committal. What happens when a surety dies? The estate of the surety is discharged from liability if surety dies before forfeiture. Then the accused will be or may be required to find a new surety. That is the rule under section 129. The defense counsel should alert the court promptly and seek directions to avoid suppress remand due to no valid surety. I think that's more of self-explanatory. So what is the step-by-step forfeiture of recognizance or bond? So the courts must satisfy recognizance has been forfeited and record grounds of proof. Court calls upon the person bound to pay penalty or show cause. If no sufficient cause and penalty penalty is unpaid, there is attachment. If unrecoverable, jail. The court may remit part of the penalty. So we should understand this, that forfeiture is not automatic. There is a show cause stage and the court may remit part of the penalty. Defense counsel representing the surety must treat forfeiture like a mini trial. Challenge proof of default, show efforts to trace accused, show reasons beyond surety's control, and seek remission. But it happened in Kenya kweli? Kori. At the constitutional standards, what compelling reasons mean? Compelling reasons in the sense that we want to deny this person bail. As I indicated earlier, per Article 49(1)(h), bail is as of right unless compelling reasons exists. So the prosecution must show the real risks. Number one, the accused is flight risk, has past absconding, no fixed abode, foreign status, severe sentence incentive. There will be witness interference, render kutishia the witnesses, public safety, if it regards capital offenses, and integrity of the investigation, co-accused at the large, risk of obstruction. Then defense must answer each risk with counterfacts and propose conditions that neutralize it. You can propose to court that the accused is not flight risk. In fact, will be reporting to court. He is willing to deposit cash bail. That I am willing to surrender the passport and everything for the accused. We're just countering whatever the prosecution is saying. In Republic versus Ngaira, last year case, there was a bond application where the prosecution opposed the release alleging flight risk and possible interference, but placed no cogent, particularized evidence beyond suspicion, while the pre-bail report showed compliance and stability. The issue was whether the prosecution has discharged the burden of proving compelling reasons to deny bail. The High Court held that compelling reasons must be supported by evidence and not speculation. Found none had been proved and admitted the accused to bond with non-interference and travel restriction conditions. You see, even for the application of compelling reasons to deny a bail, the prosecution still has the burden beyond reasonable doubt. These are a draft of how to make an application for bond when one has been denied. You seek orders that the accused be released on bond pending trial. The court be pleased to set conditions including reporting to the IO once a week, and contact with prosecution witnesses, restriction from visiting complainants' residence, any other orders. Then you give the grounds. Number one, Article 50, presumption of innocence. Article 120, Section 123, bail as of right. You just justify the reason that you need these orders. Then also, any application must be supported by an affidavit giving the grounds in an evidence manner sworn. So assuming you are on the prosecution side and you are vehemently defending or objecting to this application, you need to put it clearly that the accused is flight risk. There will be witness interference. Investigation integrity will be compromised. So that's all. Application for surety discharge, you do a chamber summons because you are not party to that suit. You are not the accused and you are not the republic or the state. Therefore, the correct format is the chamber summons. Let all parties concerned attend the honorable chambers where the applicant applies that he be discharged from the surety bond executed on behalf of this. The court issues necessary warrant to bring the accused for directions under this. Then you give your supporting affidavit. What are the reasons? Why do you need this? Why do you need to be discharged? Why do you need your bond discharged? Basically, that's it. And then, as I indicated earlier, bond is not just forfeited like that or cash bill forfeited like that. There needs to be notice to show cause. So the defense will respond like this. You will challenge on whether forfeiture is proved to satisfaction, show efforts by surety, that is calls, visits, reports to police, attempts to surrender, show reasonable cause, that the accused is hospitalized, detained somewhere else, in criminal litigation. This is where you have the basis or the start of your project. You lock the theory of the case, obtain and index statements or exhibits, agree on admissions where are safe, identify any interlocutory application you are going to make, and schedule witnesses' availability to avoid adjournment and later appeals. For the witnesses, remember, each witness must have a particular role. You need to have your theory of the case. We'll start by this, this, and this. This is the plan. Yani ramani iko hivi. I will call the first witness who is the accused. His role is this. Pa, 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 pa. Then I have this other person. If you are pleading alibi, the other person anakuja. What's your role? Unampatia vizuri, anajua the role yake ni gani in this particular suit. You don't just call witness for the sake of calling them. So for the defense, you need to ensure that after the client conference, you have the chronology. You know what kind of theory you are going to utilize. Then, most important, have we complied to bail? Disclosure requests. Important exhibits or statements that you are going to require. Witness plan. Who do you call and why? You don't call them for the sake of calling them. They need to have a reason. Then have the plan of cross-examination. Create those doubts. Then have the application plan on bond review, severance, amendment, exclusion, and everything. For prosecution, most important, the charge sheet. Does it disclose the charge in the correct manner? Is it lawful? The ingredients. Is every element mapped to evidence? You also have to schedule your witnesses. And for prosecution, they have the obligation of disclosure to the defense. So for the prosecutor, you need to have that log, that email, that received stamp, that everything that you can prove that I shared this and this and this and this, so that the Defense won't say that you are introducing new evidence that they don't have. So basically that is it on the introduction. I now go to the trial process and matters arising. So at the end of this discussion, you should be able to run the criminal trial from opening to judgment and sentencing through making or opposing trial mid-trial applications, that is the no case to answer, amendment, voir dire or confession, witness handling, and draft the essential interlocutory application. And no, your applications will be based or anchored on what? So the application itself. So criminal trial is a statutory workflow. Each stage is designed to protect the accused from arbitrary conviction and to protect the public interest in accurate fact-finding. Article 50 supplies the minimum fair hearing rights. The CPC supplies the mechanisms, and the Evidence Act supplies the admissibility and proof rules. So your job as counsel is to ensure the court stays within these rails. If you miss a step, for example, failing to record whether the accused is put on his defense and what options were explained, an appellate court may set aside the conviction. And if you believe the evidence, even if you believe the evidence was strong. Article 50, right to fair hearing. Practically, you need to, whenever the charge is read, ensure the defense or the accused person understands the charge and is given adequate time to prepare his or her defense. Right to be present and to participate. You are conducting hearing and the accused person is in remand. That can't happen. Right to challenge evidence, cross-examination, objections, public trial and reasoned decision subject to lawful exceptions. So the accused person must have the opportunity to test prosecution's evidence, which means meaningful cross-examination and access to material the prosecution will rely on. I talked about disclosure. So the court must manage the trial in a way that does not ambush either side, and the magistrate or jail must give reasons for rulings, especially when admitting contested evidence or rejecting a defense. This tracks down to what are the ingredients of a correct judgment. Identify the parties, the facts which led to the issues, the evidence by the prosecution, the countered evidence by the accused person. Anchor your arguments into law. Why did you accept this evidence, or why do you reject this evidence? Reach to the final conclusion on whether you are acquitting or convicting, having given the reasons. So basically, in that sense, you will have put in place Section 134 and Article 50 on the minimum conditions during hearing, which must be fair. Opening statement. High Court rule and the practical equivalent in magistrate court. In any other trial or in all trials, this is what happens. The prosecution opens the case, calls witnesses, and adduces evidence. In High Court trials, Section 300 states, the advocate for the prosecution shall open the case and shall call witnesses and adduce evidence. In magistrate court, the practice is similar, even where section number differs for subordinate procedure. So the prosecution must still present coherent opening and then lead evidence. The key training point is that your opening is not the final submission. Your opening is a structured promise. These are the ingredients, these are the witnesses, these are the exhibits. This is why identity, intent, possession is proved. And you realize that a weak opening usually signals a weak ingredient matrix and produces a messy trial with adjournments and contradictions. Examination of witnesses. Examination in chief. Build the narrative and prove ingredients. Each witness must have a defined job. Identification, a scene, medical injury, recovery, chain of custody, expert opinion, investigating summary. If a witness is not an ingredient or supporting credibility, they should not be called at all. Cross-examination. You test the evidence adduced in cross-examination. You test perception. If it's ID parade, how was the writing? Could you see? Memory. How long? You're talking about something that happened 10 years ago. How can you remember that with precision? Bias. What is your relationship with this person? And possibility. Logically, can that happen? In the examination, you just repair the confusion that the opposite side of the opposing card has created. You cannot use it to introduce new matters at all. Apart from the general witnesses, there are special witnesses. Number one, children of tender years. Tender means 7 and below. I think 8 and below, I'm not sure. So, we have two sections that work hand in hand. Section 19 of the Oath and Statutory Declaration Act, which the court must form an opinion whether the child understands the nature of an oath. If not, the court may still receive evidence and the child has sufficient intelligence and understand the nature of telling the truth. This is commonly called a voir dire for child witness. And I remember Mr. Mwai insisted on this. Conducting a hearing within a hearing. Unsworn child evidence needs corroboration. If after conducting the voir dire, the court forms the opinion that this child cannot give a sworn evidence, then the information that the child gives must be corroborated by another evidence. However, if the court forms the opinion that the child understands the nature of task that he or she is being asked to give, and directs that sworn evidence be given, in sexual offenses particularly, you don't need to have corroboration. So unfair. So, Section 124 of the Evidence Act. The accused shall not be convicted unless corroborated by other material evidence implicating him. However, there is a proviso that as in sexual offenses, the court may convict on the victim's evidence alone. For reasons recorded, it is not satisfied. If, for reasons recorded, it is not satisfied the victim is telling the truth. Sworn evidence should, sworn evidence for a child must be corroborated. Generally, the court should not convict on one basis evidence. They must be corroborated. However, there is a proviso in sexual offenses. The court will convict on the victim's evidence alone if it is satisfied the victim telling the truth. Prosecution must therefore prepare number one, competency inquiry readiness, corroboration plan, medical evidence, prompt report, behavioral meaning, or relying solely on victim sexual offense and court record reasons required by the proviso. Defense on the other side must challenge whether the competency inquiry was done properly, challenge whether corroboration exists, and challenge whether the court properly invoked the proviso and recorded the reasons. Special witness number two, experts. We moved from the children, now we are on the experts. Expert opinions are admissible, but the court must form an opinion on science, art, identity, and writing, or whatever. Expert must be specially skilled and must explain methodology and basis. In road traffic accident, expert, this is just for explanation purposes only, recommends the plaintiff or claimant be awarded future of 50,000 to remove the implant. The court have held it is true that this is expert evidence, but it is not binding at all. Same concept applies in criminal litigation. The courts will use this evidence persuasively if it thinks it's fit. The court will take into consideration expert evidence and rely on it. However, and again, it is not binding at all. The expert, therefore, must show qualification and must connect the opinion to reliable material. Special witness number three, hostile or refractory witnesses. What do you do when your witness turns hostile or refractory witnesses? Although the detailed hostile provisions are in the Evidence Act and common law practice, the practical litigation point is consistent. You do not panic. You move the court properly. If your witness becomes adverse, you must ask the court for leave to treat as hostile, confront him with a recorded statement for efficiency purposes. It's either to salvage the part of testimony or to neutralize damage. Defense counsel should resist any attempts by prosecution to read in statements as evidence of truth without proper foundation and should stress that prior statements are generally for impeaching credibility unless they fall under an admissibility rule. Therefore, if your witness turns hostile, you seek leave to treat them as hostile and cross-examine on prior statement. However, prosecution could argue that prior statements are unreliable at all. They don't fall under the admissibility. Production of exhibits. You must prove or build this three-layer proof. Number one, the relevance. What's the importance of this exhibit that you're trying to give? What's substantive value do they add this suit? Number two, authenticity. Six, eight, asks in electronic evidence, the certificate of production from part, then stored in parts and code. You have to show that who controlled who moved. That's we talk about the elements met. Again, Evidence Act, section, it's 111A, or I'm not sure. Of that person's choice, and were all that govern confession present. Is that recorded? If it's if no, or evidence. So the power 1.5 and section 1, I think it's 11 show evidence to consider all those ingredients confession. So the forward confession that at the stage correct is a fussy case. In the opening of a case, the no case to answer just as the prosecution proven a fussy case. If yes, prosecute the accusation is on defense section 3061 of PC. police and now in court you can't prove. Ilitoka kwa accused person ikiwa 1 kg imefika kotini ikiwa 10 kg. You can't explain that. And lastly, inadmissible confession. So the lesson is that you must match the complaint to the correct procedural vehicle. Do not file a constitutional petition where the CPC already provides a direct remedy unless you can show exceptional abuse of process, illegality, or violation that cannot be cured. can. These are drafts for change, the draft application for change of venue or transfer, often used in politically heated inquests. You'll be seeking the transfer of this for hearing and determination, direction to be issued on the file and bond. Basically, same transfer whenever you feel like there is any conflict. Extradition proceedings. Important things to note. In extradition, you have two sections. Section 77, no, not section, section 8 of the Extradition Commonwealth Countries Act, and again section 8 of Extradition Contiguous and Foreign Countries Act. Cap 77 gives the authority to proceed, notice to be given to DPP, and DPP may cancel any warrant. For 76, committal or discharge based on authenticated foreign warrants. I need us to understand extradition in this way. You must satisfy that the offense that this person committed is a triable offense in our country. The role of the magistrate is limited to identifying whether that crime or offense is triable in our republic. That role must not exceed to trial. In DPP versus Okemo 2022 matter, it arose from a dispute over which constitutional office had authority to issue and authority to proceed in extradition after the 2010 constitution. The issue was whether extradition proceedings are criminal in nature and therefore within the DPP's mandate, and whether an authority to proceed issued by the DPP was valid. The matter went all the way to Supreme Court, and it held that extradition proceedings in Kenya are criminal in nature, must be construed to conform to Constitution, and the DPP, not the AG, is constitutionally mandated to initiate and conduct them under Article 157. With the AG's role limited to executive transmission of request and allowed the appeal so proceedings continue. Therefore, extradition is the business of the DPP. It's only the DPP who can apply for orders of extradition, not the AG. The AG will only facilitate in executive transmission. I believe that's home. As indicated earlier, we have two statutes, Cap 77 and Cap 76. You just need to grab Section 8 of Cap 77 and Cap 76. So, the first step is classification of the requesting state. Then you quote the relevant Section 8. Under Cap 77, arrest can occur after authority to proceed or even before it on information the fugitive is in Kenya. A crucial built-in safeguard is Section 8.3. The magistrate must notify DPP and transmit evidence. DPP may cancel the warrant and discharge the fugitive if DPP decides not to issue authority to proceed. We have seen that extradition is the business of DPP and not AG at all. Under Cap 76, the committal test is explicit. Authenticated foreign warrant plus evidence that would justify committal if offense committed in Kenya. If not met, discharge. Therefore, the magistrate decision on whether to commit or discharge is evidence-driven. For accused fugitive, the evidence must justify committal as if the offense was committed in Kenya. For convicted fugitive, the evidence must prove conviction under Cap 76, explained above. If committed, custody pending executive surrender warrant. So this is like a committal mini hearing where the prosecution must present properly authenticated documents and sufficient evidence threshold. but not beyond reasonable doubt to justify committal. The defense must not argue full innocence. It attacks whether the legal threshold is met. Is this triable? Is this offense committed triable in Kenya? After committal, the magistrate sends certificate and report to the CS, and the magistrate ananawa mikono naenda kwa the AG for transmission. Thank you. So if you do an application in extradition, just like any other matter, you can do for an application for bail and a notice of motion seeking for orders that the person be released on bail or bond pending termination of committal proceedings. And you can give conditions so that you might beat the allegation of flight risk, contamination of witnesses, such like you deposit the passport, reporting to the IO, residence addresses, you give a surety, and you support it with an affidavit. We now go to miscellaneous applications on freezing, search, confiscation, and summons. So, in the trial process, at any juncture, you might need to do an application as a prosecutor, whether you need freezing orders, search orders, confiscation orders, or any summons. So, summons in financial crime, you should not wrongly jump on to search everything. Courts expect proportionality. Begin with document compulsion unless there is credible risk of destruction or concealment. In civil litigation, we'll call that Anton Pila. Your affidavit must be precise. What document do you want? Which account? For what period? And are they relevant to, why they are relevant to locating proceeds or proving the offense? Overboard fishing invites refusal or later quashing. Therefore, the threshold here is very high, just like in requesting or seeking for Anton Pila orders. A draft is here. The notice of motion requires preservation, 6 orders that the preservation of freezing orders issued be varied, rescinded to the extent that per month be released for living, this. You also need to do a supporting affidavit, which will have full financial disclosure depending on the type of application you are making. This is just a summary on whatever you have done. I think we are coming to conclusion. Habeas corpus. I won't go into details because I'll give the content or context, what is most important. Capture these things. Number 1, orders are issued by the court. For the applicant, they must prove these things. 1, the body in quotes is within the jurisdiction of Kenya. Number 2, the person was last seen with the OCS or whoever you want the habeas corpus orders be directed to. Number 3, the subject exists and is missing, unavailable to family or counsel. And lastly, urgency, risk to life, liberty. Think of it in in terms of Gen Z demonstrations. Number one, we need to prove that the person is not with the family. He is missing. OB reports, something like that. Number two, the doctrine of last seen. This person whom you are seeking these orders was last seen with who? Alikuwa arrested pale CBD under police vehicle number this and this, akawekwa kwa boat. That is the doctrine of last seen. Number three, we believe that the person is within the Republic of Kenya. The person was arrested yesterday in the morning. We have the reasons to believe that amepotezwa na mapolisi wa Kenya. Therefore, there is no way that person can be outside the territory. Number four, the person should have been produced in the court within 24 hours. We have reasons we have reasons to believe that the police might in one way or the other have the intent of taking his life. You just show the urgency, the risk to life, and that liberty is utmost at the moment. You can even give prior accounts that watu wamekuwa wakishikwa hivyo wanapotea wanapatikana wamekufa. Therefore, you must prove those three things. If the person is not within the territory, don't do the application. You have no recourse completely. If the person has not been reported missing, you have no recourse. If the person cannot be identified, mara ya mwisho alionekana wapi, you have no recourse. Therefore, you need to prove these four elements strictly. The relief that the court might grant are that the person be produced in open court on a fixed date and time. Aliarestiwa pale CBD on Monday. Then the application is done on Tuesday. That person be produced in court by the close of business on Wednesday. Release if the intention is unlawful, or directions to charge or arraign promptly. Rarely, release is an option. Therefore, directions are normally to charge or arraign completely in court within fixed time or date. Orders for access to counsel, family or medical care pending hearing. Babu Owino 2024 demonstration. Habeas corpus was given, and one of the orders was that the person, because alikuwa amechapwa, he be given access to his personal doctor and wakili. Basically, that's all about habeas corpus. I can read just one case here. In France, Bernhard Heinrich von Bülow vs. Republic. It involved an application seeking habeas orders in relation to a person alleged to have been detained outside Kenya. The issue was whether the High Court of Kenya had jurisdiction to issue habeas corpus directions where the subject was not within Kenya's territorial limits. The High Court held Section 389 is very specific. The person must be within the jurisdiction or the territory of Kenya, and the court will not issue orders in vain that are unenforceable. The application was dismissed. Therefore, my point number 2, the person must be within the territory. These are an application, notice of motion, or originating summons. The way you feel it's okay. If the person has been arrested, or if the person has already been arraigned in court but amepotea in one or the other, you do a notice of motion because a case is equal. If the person has not been arraigned or the person was arrested na akapotea, you do an originating summons seeking the following orders. The court be pleased to issue directions of the nature of habeas corpus compelling the respondents, that is the IG of police, the OCS of particular station, the DPP, to produce the body of or the person of blah blah within this time. Upon production, the court be pleased to order that the person be released if detention is unlawful, or be presented before a competent court of jurisdiction without delay. Pending hearing, the court grants interim orders, access to family, doctor, nini, then you do a supporting affidavit. Basically, that's everything that you need to capture in regards to habeas corpus applications. A person is missing and there is report. Doctrine of last seen, alionekana na nani? The person is within the territory. Hayuko nje. You need to prove those things. Judicial review is our last topic, and it must not be confused with appeal. Just like the Constitution gives it, it tests the legality, the procedure, the rationality and the procedural fairness of decisions or actions by the public bodies, including DPP. The governing rules are exhaustion, plus the procedure, appeals from JR decisions, Section 9 of the Fair Administrative Actions Act. So how does JR fit in criminal litigation? It controls the process, not the merits of guilt or innocence. The remedies will be certiorari, prohibition, or mandamus. I believe we are all aware on that. Just like constitutional reliefs offered in JR, in criminal litigation, they are still the same. Certiorari, you quash everything, the decision. Prohibition, you stop certain administrative action. Mandamus, you compel that decision to happen. However, Section 9 of the Fair Administrative Acts gives the exhaustion rule. Courts shall not review unless internal mechanisms and other statutory remedies are first exhausted. If not exhausted, court directs applicants to exhaust. Then courts may exempt in exceptional circumstances in the interest of justice. So, explanatory note is that Section 9 is the statutory codification of exhaustion. In exams, you quote Section 9.2 and then explain its logic. Courts do not want litigants to bypass specialized statutory dispute resolution mechanisms. You must identify the alternative remedy. Kuna appeal or revision under the Criminal Procedure Code? If it is, then don't go to judicial review. Internal review within an agency, tribunal appeal, or statutory appeal. If you cannot exhaust or exhaustion will be futile or oppressive, you apply for exemption under Section 9.4 and you must plead exceptional circumstances with evidence. So common situation where you can do criminal litigation JR, challenging prosecution decisions, decision to prosecute. If it is driven by malice, you do a constitutional petition or judicial review, depending on whether you need damages or not. You can challenge subordinate court's process decision without appeal. Revision is often better. So judicial review only if pure jurisdictional process is illegality. You are tried of murder in the magistrate court. That process in itself is a nullity. You can challenge seizure or freezing orders, often statutory variation routes first, but the most important thing is making an application in the High Court. If not, you go under the exemption rule under Section 4. Under subsection 4 of Section 9 of the FAA. So, in doing a judicial review, you make an application in this manner. I believe you can all see. In the High Court of Kenya, judicial review application in the matter of an application for judicial review of orders of certiorari, prohibition, or mandamus. You state the particular facts. You accompany it with a verifying affidavit. Then If you are bringing it under the subsection 4 of exemption, you need to plead that exhaustion. That's all about judicial review. Procedures in special cases, children court, you're very direct. So I don't think I'm going to handle this because this is very, very direct. And that's all. Maybe you can hear comments from Albert. Sawa sawa, asante sana. Anyone else who wants to comment before tukafunge, or question or anything? Yes, Maurice. Maurice can go first, alafu Albert.
Mine is to first thank you for the good commend you for the wonderful that you've done. This is my first meeting. If this is the kind of work that you're doing, guys, this can really be of much help, because I've seen within a span of less than 3 hours you've been able to capture, or rather tackle, the whole unit, and it has even made it more easier and understandable. I bet if I now go to criminal class, and if the lecturer just skims through it, and be in a position to understand and be able to go through it. Thank you, and I look forward to joining you anytime that I'm available, so that you can help me grasp content and tackle things well. Thank you.
Asante sana Maurice, asante sana. Yes, Albert.
Yes, thank you, Balozi, and thank you for the wonderful session. You've taken us through the whole of criminal litigation. I didn't imagine it could be possible, but through your assistance and your breakdown, it has been very resourceful and impactful. I just had a small question, or rather clarification. When you were talking about the witnesses, I didn't want to interject with your flow, but I wanted to consult where you would have bestly put the state witnesses. And the reason why I'm asking this, I think all of you can bear witness. It's invoked by the fact that it is part of our project, where there are several offenders who commit an offense, then one admits, and the prosecution now decides to use them as a state witness, such that they can get any other information concerning the other offenders now. I was just hoping that perhaps you'll shed light on that, such that it can give us a clear guideline when we go back to our respective firms on the project. Thank you.
Thank you sana Charo. Vile umesema tu state witnesses ni mtu ameshikwa na akaamua kujitolea to testify on behalf of the government or the state. The person says sijui ndaiweka aje, like you want to know whether atakuwa charged ama just come out clearly, kindly Charo.
Yes, exactly. I just wanted to know the implication and even the relevance of having that state witness, if they can be charged, or rather what parameters do the state have to look before they can make one a state witness. Because I'm trying to imagine a situation where anybody will be arrested. Then of course, the police have that sweet tongue of telling you, wewe niambie tu kweli nitakuachilia. Then everyone can use that opportunity now, so long as you can say the truth and no further charges will be conferred against you. Just become a state witness and you escape that case. So what are the parameters that the arresting officers, or rather the police, should take before they make someone a state witness, and how viable is the information from the state witness.
Sawa sawa Albert. So ya Victor nataka kuongea. Sawa sawa.
Okay, thank you.
Yes, Victor, thank you. Tu umesema the first important thing is the witness prosecution agency. So the court can order concrete protective measures and coordinate with the witness protection agency. That is, afichwe ni nini asionekane, just to protect him from the rest of the co-accused. Protection orders can also include witness protection box. Sindio Victor, sindio hiyo? Yeah, so you must first approach the witness prosecution agency for assessment or MOU before moving court in the ordinary course. If the person is still accused, ama ni suspect ama co-accused, regular remand or bail regime applies. If they are cooperating sasa, the prosecution may consider withdrawal or discharge so they can testify as witness, then pursue protection measures if risk is shown. Naona kama nasaliti wenzake. Therefore, if the prosecution decides to withdraw their case or discharge them, they must pursue protection measures. Umeuliza about parameters. For the parameters, you can sikuelewa vizuri, but in my view, I think that the prosecution should confirm kwanza the status, whether this person has been previously arrested, explain the change or discharge or nini, risk profile, whether this person akona any intimidation history, vulnerability against the other co-accused, operational feasibility, which kind of offense na huyu jamaa kisaliti wenzake itakuwa aje. Then the other parameter will be the WPA, the Witness Protection Agency. On how you are going to protect this person if at all ameamua kabisa kusaliti wenzake. So naona section 87 inasema that discharge is not acquittal. So after this person has been discharged by the prosecution so that they can use him in the benefit of the witnesses, bado the state may recharge him again later on. True. Sijui Albert kama tumekujibu ama bado.
Yes, umenijibu, shukran sana. Lakini on the parameters,
yes,
I was joining another group yenye walikuwa na discuss.
Yeah, maybe you can just contribute.
Particularly kwa ile project work yetu.
Nasema
in the parameters, first the prosecution or whatever stage that state witness will come handy, they must consider if it's really relevant in the investigations. Juu hakuna venye an accused person anaweza kuja tu alete information kwa askari ama the prosecution such that afanye witness state witness yet wao wenyewe wangefanya uchunguzi bado wangepata the same thing, so they'll have to look at such how relevant is it or Exactly. Kuna wengine wanatakaga tu kujitoa. So if the investigating officers have proved that it is almost impossible to get such information without the aid of this purported state witness, that's when they'll admit them. But if they would have, through other means, gotten the same information concerning the investigation without the aid of this purported state witness, they won't admit that. In fact, what sasa they will charge that accused alongside the other people.
Sawa. Thank you. Shukran.
Shukran.
Victor, back to you, Victor. Kwani Victor anahitaji jina tena, si ni criminal litigation prevention? Very important. And end it there, but you can log out.
Okay, good evening.